Welcome to literary and jury charge practice. Let's go ahead and get started with this jury charge. Okay, here we go. Ladies and gentlemen of the jury, in giving you the law in this case, the court wishes to make it clear at the outset that the court will not discuss the facts because that is your main function. The court will simply give you the principles of law which apply to criminal cases in general, and then discuss with you the elements of the crime which is charged in this indictment. The function of the court is to conduct the trial in an orderly manner, to rule upon questions of law arising in the course of the trial, and to instruct you as to the law which applies to the case. It is your duty to accept the law as the court states it to you, and you should consider all the instructions as a whole. The function of the jury is to determine the facts. You are the sole and exclusive judges of the facts. You should determine the facts solely from the fair consideration of the evidence. What the verdict shall be is your duty and responsibility. It is your own recollection of the evidence that will control during your deliberations in the jury room. The statements of counsel are not evidence. They are only intended to assist you in understanding the evidence and the contentions of counsel. The indictment itself, which you may take to the jury room with you if you desire, is not evidence. It is merely the formal manner of accusing a person of a crime in order to bring him to trial. You must not consider the indictment as any evidence of the guilt of a defendant or draw any inference of guilt because he was indicted. In this case, ladies and gentlemen, as you are well aware, there are two defendants. In giving you these instructions, I will refer mainly to the defendant because what I say applies to each defendant. In all criminal cases, there are certain important rules that you must bear in mind. Among those is what we call the presumption of innocence, the burden of proof, and reasonable doubt. In every criminal case, the law presumes a defendant to be innocent of the crime charged. The law permits nothing but legal evidence presented before the jury to be considered in support of any charge against the defendant. The presumption of innocence alone is sufficient to acquit a defendant unless you are satisfied beyond a reasonable doubt of the defendant's guilt based on all the evidence introduced in the case. All right, now let's try some literary practice. This is an article in the Journal of Court Reporting, in a Journal of Court Reporting magazine. And it's called Managing Your Online Reputation in an Increasingly Social World. So possibly some good advice in here. Okay, here we go. It's hard to imagine a time before social media had such a strong presence in our lives. It's become commonplace to share almost everything on social media. Images of food, momentary insights, and weekend plans. But it is important to consider how social media influences professional image. According to a PEW Research Center poll, 74% of internet users are on at least one social networking site. This means users range from personal friends to family to instructors to hiring managers. Students can bet that anything they or their friends ever post can be seen by all of these people at any point in time. By the time that students graduate and are looking for work, they may have forgotten what they posted that first year in school, but rest assured that the internet did not. Avoiding social media, however, is not a good strategy either. The trick is to manage the risks and cultivate a professional image. Used properly, social media has professional benefits for students as well. Social media has allowed some graduates the opportunity to easily network with employers in different states and then ultimately relocate to another state, said Nikki Rodriguez, the director of admission at College of Court Reporting in Hobart, Indiana. Some of those opportunities may not have come about without social media. Kinsey Benoit, an official in Groves, Texas, found the ability to network with employers to be valuable when she was job hunting. I tried out for 4 officialships before my current position, said Benoit. All of them were referrals from people I had only known online. I put the word out there that I was looking for an officialship, and people started tagging me in all sorts of job postings online. Another benefit of using social media professionally is access to online groups of like-minded professionals, which offer both the opportunity for skill building and camaraderie. I'm able to help new reporters when they have job-related questions and also debate some issues affecting reporters and captioners in general, said Laura Fowler, RPR, CRC, a firm owner from Modesto, California. It's a great way to keep up on our profession. It's awesome when I or someone else needs help with anything, and all we have to do is post the question, and everyone responds quickly with great answers. It is our lifeline to the world, said Jennifer Bonfillo, RMR, CRC, a captioner from Delray Beach, Florida. It baffles me how captioners were able to do their jobs before the internet, not only from a research perspective, but a human interaction perspective. All right, well, we'll read more of that another time. Let's see here. I was just trying to see if there was any words that we might want to work on. Official ships. Official ships. And let's see. Excuse me. I don't think I see anything else. Again, though, very interesting. So we'll, like I said, we'll keep working on this article. Let's get back to some jury charge practice now. Ready? In criminal cases, the people are considered the plaintiffs. Before a trial, a person charged with a crime is given an opportunity to make a plea. If it is the people, not an individual, who is bringing forth the action, the people are the individuals who are represented by an attorney. An attorney appointed by the state is chosen as a representative of the state. At the trial, the people bring forth the suit, but it is up to the jury to decide the guilt of the party who has been charged. The jury will make the decision whether the person is guilty beyond all reasonable doubt. The jury may decide that the individual is not guilty beyond all reasonable doubt. The attorneys who represented the state in this criminal case presented enough evidence to convince the jury of the person's guilt. The defendant was confined to prison. The defendant received a reprieve because new evidence was found. The defendant was granted the reprieve while the new evidence was being examined. The defendant must be shown to be guilty beyond all reasonable doubt in the case. If this is the case, the result will be that the defendant is found to be not guilty. The jury was convinced beyond a reasonable doubt of the defendant's innocence. It could not find in favor of the defendant. For this reason, the defendant was sent to the penitentiary without any opportunity for parole. The attorneys that represented both sides were convinced of their positions. The jury decided the facts in the case based upon the evidence presented in court. The new evidence was not available until the defendant had been convicted and was in prison. With the new evidence, the defendant was able to get a reprieve. The order was granted by the governor. The governor is the only one who can grant a reprieve in cases such as this. Evidence presented in testimony at trial was called into question. Testimony consists of the words of the witness taken down while the witness is under oath. in addition to testimony as a means of offering evidence to the court, the attorneys had any number of different types of exhibits to use as proof of their positions. Both sides had many exhibits to support their sides. The new evidence was determined only after the jury had decided the case. What followed was that there was an absolute pardon of the defendant. When testimony is entered into evidence by the plaintiff, that evidence is used to prove the plaintiff's case. Only new evidence can change the decision of the jury. The defendant was released from confinement only after the new evidence in the case was examined. During the trial, the witnesses were called, starting with the witnesses for the state. The state had to put on a good case to prove the case beyond a reasonable doubt. The state first presented one of its witnesses and questioned the witness under oath. Let's see what kind of, if we have any maybe challenging words in this one. I think this one hopefully went pretty well for everybody. We have innocence, penitentiary. I'm sure there's a brief for that. I don't have it. I'm sorry. Let's see, reprieve. Confinement. All right. Let's get back to our article from the NCRA, National Court Reporters Association, the magazine, and see what other advice we have for using social media. Okay, here we go. The field has shifted so that our professionals now mostly work from their homes with few, if any, interactions in an office setting, said Karen Yates, RPR, CRR, CRC, a CART captioner from Minden, Nevada. Social media now fills the role of a virtual break room. We vent our frustrations, get advice, seek recommendations on software and hardware. Yates also pointed out that online forums give professionals an opportunity to connect with people they would not be able to meet face to face. The value of social media groups is not limited only to working professionals. Joining these groups as a student can provide a bit of a leg up while learning about court reporting and captioning. I vet questions from working reporters on scenarios that I know I will one day face myself, said Catherine Schilling, a court reporting student at West Valley College in Saratoga, California. I like to think that I can avoid making some mistakes when I start working by learning from those who have recently gone through it. There are so many benefits of using social media, but the key is being cautious with profiles and posts, keeping the P's in mind. Pause before you post. Sometimes simply taking a few seconds to reconsider a post is enough to maintain a professional appearance. Assume anything and everything will be seen by anyone and everyone, said Bonifio. If you wouldn't say or do it in front of your grandmother, employer, child, police officer, or competitor, then don't post it online. Once it's out there, you can't take it back. All right. I think that one's really good. A good bit of advice. Sometimes I will say what I've even done is maybe sleep on it even before sending an email. I mean, whatever it is, because social media and email, it's out there. All right, that will conclude our literary and jury charge practice for today. Thank you.